Stephen M. Cohn, the Executive Director of the National Whistleblowers Center and the attorney for the FDA whistleblowers. In January of 2012, we filed a lawsuit on behalf of 6 FDA scientists and doctors, 4 of whom had been fired, alleging that they were retaliated against after they filed complaints concerning unsafe medical devices. They also alleged that part of this retaliation was being subjected to a targeted surveillance campaign into their private emails and Gmails. A central part of the lawsuit is alleging First Amendment violations. Government workers have the right to blow the whistle. It's First Amendment protected speech. So whenever the government retaliates or takes an adverse action against a government worker, it better not be in violation of the First Amendment. If so, we can stop it and enjoin it. And in this case, raising concerns about unsafe medical devices was protected speech under the First Amendment, and then we're challenging a series of actions committed by FDA, such as the termination of one of the doctors and instituting surveillance on the entire group of whistleblowers as violations of the First Amendment. Because these whistleblowers worked for the government, the Fourth Amendment applies. It's different than the private sector. And under the Fourth Amendment, the government needs a warrant to conduct surveillance. But because they're employees, there are some different rules, and they can do warrantless surveillance, but they have to meet 3 criteria. It can't be for an improper purpose, and it has to be reasonable in scope and limited in time. And in this case, the purpose was retaliatory. They targeted them because they were whistleblowers. So it's an improper purpose. The scope was simply outrageous. As we now know, they weren't looking for just improper leaks of confidential information. They were actually targeting them for their whistleblowing, for communications to Congress that are protected under law, to communications with a group known as the Office of Special Counsel, for which there are specific laws guaranteeing that these employees could communicate with those agencies confidentially. So the purpose, the scope, and duration. We don't even know the duration. Unlike typical searches where it might be for a week or a month, this could, for all we know, have been going on for years. And again, it's retaliatory to put someone on some intense search and seizure operation for years. You just can't do it. Sure. The rules for the private and public sector are different. In the private sector, companies can search their employees, but there are limits concerning privacy, often under common law. In the government sector, the rules on privacy are tied to the Fourth Amendment and your right to be free from unreasonable searches and seizures. In this case, the FDA gave these scientists, in some cases years ago, laptops with permission to take them home, and here's what's key, permission to use them for personal purposes, to access their Gmail accounts online, to access accounts that are passcode protected and encrypted. And by letting the employees access passcode protected accounts, that's consent for them to use it personally, which was explicitly given. But instead of honoring that privacy, they put in spyware that actually allowed them to break codes, learn passwords, do screenshots of anything and everything, access medical information, financial information, whatever may pass through that computer. And that's where it steps over the line. This wasn't monitoring work. This was monitoring personal activities done with permission. That's another very troubling fact, and I think it really is critical. FDA thought that there was a leak of confidential information, so their pretext for this monitoring was a leak. And they went to the Inspector General's office, and the IG reviewed the material and came back and said two things. First, no evidence of a leak. Second, what these whistleblowers are communicating is protected under law. This is protected whistleblower communications. So the agency knew, literally within a week or two of commencing the monitoring, that their predicate for the monitoring was unjustified, and that what they were monitoring wasn't misconduct, it was protected activity. So as I said before, it's the predicate, it's the targeting, knowing that it's a group of whistleblowers, and targeting them because they were raising concerns, that creates the constitutional violations. This surveillance remains mysterious. Now, the agency uploaded on the internet 80,000 pages of documents, which is simply outrageous. Personal information of whistleblowers. Loaded. 80,000 pages. Would you want 80,000 pages of your emails uploaded by the government of the United States onto the web? So they did it. It's totally outrageous, but it has given us a window into this spying program. But we still don't know who ordered it. And we know that Senator Grassley and Congressman Issa made specific requests 6 months ago to the FDA wanting to know who ordered this spying. And no one has stepped forward and fessed up to it as far as we can see. It's part of a process. First there's the request, then there's a denial, then the committee would have to vote subpoenas, and the subpoenas would be issued, and then the subpoenas would be denied and would go to contempt vote. In the overwhelming majority of cases, there never is a contempt vote. These matters are negotiated. And I would hope that FDA stops the stonewalling and starts cooperating. And if FDA won't do it, I hope that HHS orders them to do it. And if HHS and FDA won't do it, I hope the President cleans this mess up. Well, we have two federal lawsuits. The first is on injunctions on the surveillance and the retaliation. A second is a Freedom of Information Act lawsuit trying to get all these documents, additional documents on who ordered it, why, and when. FDA has been stonewalling that. So we have a hearing for next Monday in which we're going to be asking the court to order the production of these documents immediately.